The concepts of impracticability and force majeure are important common law and actually civil law concepts. The concept of force majeure is a civilian concept, but they're related, and they've taken on particular importance lately because of the COVID-19 pandemic. So we're going to talk a little bit about those now. So the basic concept of impracticability, which is what we, at least in the United States anymore, tend to refer to instead of impossibility, is that even though the contracting party's performance of its obligations may literally still be possible, it's become effectively so onerous that it's impracticable. So if we work through the elements of Section 261, you see that there are a number of bases that a party would have to touch before it could raise a defense of impracticability. And this always comes up as a defense, right? Because the idea is you and I have a contract, you're supposed to do X, and you say, hey, I can't do X because of some event. Well, the first point is, okay, the event, the non-occurrence of which was a basic assumption on which the contract was made, that's the trigger, right? There has to be an event, and its non-occurrence has to have been so unanticipated that the risk of it occurring wasn't allocated in the contract. So, for example, if we take the pandemic, say this is something that happened and nobody anticipated it, so we didn't allocate the risk of it happening in the contract. If that happens, okay, after the contract is made, right, we're talking about something, an event that happens post contract formation, because if the event has already happened at the time the contract is made, the parties are deemed to have contracted with that in mind and to have allocated the risk accordingly. So if we go back to the pandemic example, contracts entered into after, say, the spring of 2020, it would be hard to argue that this is something that the pandemic was something that neither party could foresee or allocate the risk of, because it was already upon us and everyone was in lockdown. So the event has to be something that occurs after the contract is made. Obviously, it has to be an event that makes the party's performance impracticable without the party's own fault. Okay, so that may be just stating the obvious, that you can't shoot yourself in the foot and then say, oh, sorry, I can't fight because I'm wounded. Now, the biggest question that comes up is just, well, was this event, the non-occurrence of which, such a basic assumption on which the contract was made that it renders the party's performance impracticable, and therefore they should be excused from performing? Because at some level, pretty much everything is foreseeable, right? Pandemics are foreseeable in theory. An asteroid hitting the Earth is foreseeable. Whether anybody really plans for it and crafts their contract language to take into account those events is a different question. But this is where the battle often takes place, is a difference of view of whether the risk of the event happening was really allocated or not. If a court or arbitrator finds that the risk of an event in fact was allocated in the contract, then that's going to determine whether or not the performance is discharged. So if the party claiming discharge in fact had taken on the risk explicitly or implicitly through the contract language, then that party is going to be hard pressed to then say, oh, I can't perform because it's impracticable for me to perform. So these are relatively unusual cases where impracticability actually works as a defense. I don't have in the slide here, but in the comments to the restatement, it's pretty clear that to be impracticable means more than just to be more expensive. It has to be so ridiculously more expensive as to be prohibitive, essentially. So simply a rise in price doesn't necessarily make something impracticable. If it's an extreme rise in price, that might be, that's hindering a party's performance. That might rise to the level of performance becoming impracticable. But courts are very reluctant to say that simply even an extreme rise in price should excuse a party's performance, because after all, that's part of the point of having contracts, is to allocate the risk of price fluctuations either up or down. Then the sort of to close the loop, if you can show impracticability, what does that get you? Under the literal language of Section 261, it gets you discharge from rendering that performance. Okay, it doesn't necessarily get you out of the contract altogether, and it doesn't necessarily excuse the non-discharged party from paying for any benefit that it's already received under the contract. So it's a fairly narrow category of relief. That is, it renders the specific performance that is impracticable discharged. It doesn't get a party out of the contract altogether. Okay. Now, of course, there's a caveat at the end, unless the language or the circumstances indicate the contrary. What does that mean? That's just unless the parties have allocated the risk of the event in their contract, or the circumstances indicate that the risk should be allocated to one party or the other. So 261 is a relatively unusual situation where it's going to work to discharge a party. But if all the bases are touched, if all the elements are met, a party may successfully be able to argue that its performance is discharged. Now, the relationship between impracticability and force majeure is essentially this. It comes up in the context of force majeure clauses in contracts, and these are the kinds of act of God type clauses that you see in contracts where it says something to the effect that one or both parties may be excused from performance due to an act of God, a flood, a fire, maybe labor strikes, things of that nature, or court order. These are essentially events that are outside either party's control, or at least outside the performing party's control. And so, as the Michigan Court of Appeals explained in this case, which is one of the leading cases in Michigan, at least, on force majeure clauses, is the whole purpose of that clause is to essentially identify the circumstances under which the parties agree that a given event will discharge a party or both parties from performing some particular obligation. So the way to think about the relationship between impracticability and force majeure is force majeure clauses are there to help identify how the risk of a given event has been allocated, if at all. And so if we're thinking about the elements of impracticability, and we're looking at an event, the non-occurrence of which was a basic assumption on which the contract was made, we have to consider, well, is there a force majeure clause in the contract that essentially says, yes, the parties did anticipate the occurrence of this event, and they specified what would happen in the event that the event occurred. If the force majeure clause, if there is no force majeure clause, or if the force majeure clause doesn't address the kind of event that we're talking about, for example, a pandemic or a flood or what have you, then we're left with construing the rest of the contract to see if the risk has been allocated one way or the other, looking at the surrounding circumstances, etc. So impracticability and force majeure are important concepts, and they're likely to become more important in litigation in the next few months and years as the effects of the COVID-19 pandemic continue to sort of ripple through contractual chains. But the way to think about these two is in terms of risk allocation, and has the risk of the event been allocated among the parties, and if not, what is the specific effect of the event occurring, because the effect of the event is going to determine what performance is discharged or not. Not simply that, oh, there was a pandemic, therefore I don't have to do anything, or I don't have to do anything on time, or I don't have to do anything the way I was going to do them, doesn't necessarily follow. There has to be a fairly clear causal connection between the event that occurred, whose risk was not allocated, and the specific contractual obligation that the party claiming impracticability is now unable to perform, or claims is impracticable to perform.